Good morning, everybody. Thank you so much for joining us today. It is an absolute privilege to not only introduce you to our focus dad, but also attorney and the judge, DJ Jeyaram. DJ, take it away.
Hi, everybody. Thanks for being here this morning. My name's DJ Jeyaram. I am a focus dad and have been for the last 14 years. I'm also an attorney. I do work in special needs, estate planning and guardianships, and it's always a real pleasure to speak to parents and hopefully convey some good information. I think you all can see my screen here. And today's topic is never fun. We don't like to think about it, but of course the reality is, one day, we're not going to be here. And so the real hard question for special needs families, and the one that really keeps us up at night, is who's going to do all the things for our kids that we do when we can't do it anymore. And so that's what I'm going to talk about today. I'll talk about how we try to answer that question as best we can, not just legally. We'll definitely address that, but functionally, how do we make this happen? And some of the things you can think about as you go about trying to create this plan for you and your family. So just real quick, I do have to give you the disclaimer that the information I'm providing you is just general. It's not specific to your family. So at the very end, I'll have a slide that if you do want to talk to me one-on-one about your family situation, we can set something up to do that. Okay, just a little bit about my background. Like I said, I am an attorney. I did move down to Georgia, a lifetime ago, 28 years ago, to go to Emory for law school. I did start my career with the Department of Community Health, so I know quite a bit about the Medicaid program and Katie Beckett and now COMP. Been practicing for 26 years now, and am also work as a judge in magistrate court in Gwinnett County. But the more important thing, and the reason I hope you get some good information out of this presentation, is that I am a special needs parent as well. This is my son Kai. Kai's 14. I need to get a newer picture. He's about the same size, but he's starting to get facial hair. He's looking a little older. But Kai is on the autism spectrum. He also has a condition called Williams syndrome. And what that translates into is a pretty significant intellectual disability. We're still working on potty training. We still have to feed him. We have to brush his teeth. We're on the Katie Beckett program. We're on the now comp waiting list. We've sat through the IEP meetings. And so every single thing I'm going to talk to you about today, my family has had to address for itself. And so, when we get to the end, or, Jade, if you want to do questions as we work through it, work through the presentation, that's fine. But every single thing my wife and I have had to address. And so to the extent you have questions about how I've set things up personally, I am glad to answer that for you. I'm not a financial planner, but we work with a lot of them, and I've spoken to a lot of them, so I can certainly give you information about what I've learned from them. Okay, so what are we going to do today? So there are four goals today. One is just understanding how we protect our child's benefits if something happens to us. When we're gone, how do we make sure these very important government benefits stay in place? We're going to talk about financial protections. Of course, there are finances that we have in addition to any government benefits you may get. How do we protect the finances for our kids when we're gone and not able to do that for them? And then, just as important as the first two, are personal protections. How do we protect them personally, physically, mentally, emotionally? How do we address that? And so we'll go through all of those things. And finally, as I said in the beginning, what is one of the biggest things that's different in a special needs plan, and when I say plan, I mean an estate plan, uh, is it's not a question of when we're going to use these trusts. It's not a question of when the will is going to come into play or these protections will come into play. Or if, I'm sorry, it's just a question of when they're going to come into play. And we just have to accept the fact that when we create these plans and protections, they will be used. It's just a question of when they'll be used. So I always encourage people, do it earlier if you can. Do it while we have the energy to invest in creating a good plan. We have people in our lives we can talk to. Because as we get older, it becomes harder. Our energy dips, our time sometimes dips. It becomes harder. So we want to make sure we put these plans in place, not only for that reason, but because we really just don't know when this plan will be used, whether we're no longer around because of natural causes or an accident. We just don't know. So I always encourage people to put it in place. So what are the documents we need to kind of protect our child's future? You're going to need a will. You're absolutely going to need a will, and I'm going to go into exactly why you need that will, what it's meant to do, and how it fits into the protections. You're going to need a special needs trust, or maybe not a special needs trust, maybe a regular trust for your child. But a trust plays a very important role in protecting our kids, not only financially and benefits, but also personally. Letter to the guardians. We're going to talk about that quite a bit. A lot of attorneys and organizations call it a letter of intent, but it's basically information on our kids. Child safety and protection cards, that's something that we create for our clients, but you can certainly create that on your own. There's some free ones out there I think you could probably download, but I'll explain what that is. And then guardianship, power of attorney, and trustee designations. These are the players in our plan and in our child's life when we're gone. Because you do these things for your child in some capacity or the other. Okay, when we're gone, who's going to be stepping into those shoes to assist them? How does it work? How do you choose between those things? And how do those roles fit together to create maximum protection for our kids? So I'll talk about that. And then finally, I have a little asterisk next to that, life insurance. What role does life insurance play in all of this? And there's no one size fits all answer to this. A lot depends on your personal finances. So you don't absolutely need life insurance. That's why there's the asterisks. With the rest of these things, where I just have the bullet points here, you absolutely need these. Life insurance is kind of a question mark. All right, let's talk about your wills. Why do you need a will? So a few things on that. One is, of course, when you pass away, you want to be able to dictate what happens with your assets. Okay. So in your will, you're going to have three major decisions that affects your child and protects your child. One is the flow of your estate. In other words, you have a bucket of money, a bucket of assets when you pass away. Are you setting that all to support the special needs child? Are you going to split that between a special needs child and a typical child? Are you a part of a blended family? So part of it may go to a surviving spouse, or all of it to a surviving spouse, or some to a surviving spouse and some directly to a trust. But you have to make that decision. Okay, it's not as easy as just saying, well, if I pass away without a will, the law will take care of it. Well, that's not really true. Will the law have an answer? Yes. But will they be taking care with it? No. So today, if you pass away in Georgia without a will, part of your estate belongs to the child. Now, for a typical child, it may not be as big a deal. The worst part of that is they would get their inheritance when they turn, if they're 18 or older, they get it outright. Or if they're under 18, when they turn 18, they get it outright. For a special needs child, it's completely different. If your special needs child is under the age of 18 and say you're getting the Katie Beckett waiver benefits, well, you know, when you fill out that really huge application, what they're asking about is, hey, what does your child have in their name? What money do they have in their name? What resources do they have in their name? And that's how they determine whether your child gets Katie Beckett. Among other things. But financially, that's how they determine. And they don't look at what mom and dad have or what mom and dad are making. But if one parent passes away without a will in place, part of that parent's estate can flow to the special needs child. Well, now if they have Katie Beckett, they've just lost it. Because now Medicaid and SSI is saying, oh, look, even though you have that money in a, say, a conservatorship, which is different than a trust, and a conservatorship for that special needs child, that asset still belongs to the child. You're just managing it for them. Well, if it belongs to the child, that's their resource. And now we're terminating their Katie Beckett benefits. Obviously, if the child's 18 or older and getting SSI benefits, they would lose those SSI benefits as well. So that's why we want to make sure you have a will that properly reflects how you want your estate to flow. Okay, maybe not directly to that special needs child, maybe to a surviving spouse, or maybe to a trust for the child, but not to the special needs child directly. The second big decision you're going to have in your plan will be who will be the successor guardians for your child. Now, if your child is 18 or older and has a guardian, most likely you, who's going to step into your shoes if something happens to you? Well, this is where you list it in your will. These are who I want. These are the successor guardians. Okay, you have to make those choices, because if you don't make those choices in your will, a court will look at a statute and make choices for guardianship. And there's no way a court or a judge is going to make a better decision about guardians for your child than you can, because you know the players, you know the ins and outs, you know the personalities. Courts and judges do not know that. I get this question a lot. Well, what if my child doesn't have, my adult special needs child does not have a guardian? That's fine. It does not hurt to name guardians in your will. That's not, when you name successor guardians in your will for your child, that's not you saying my child needs a guardian. That's you saying, if my child needs a guardian, this is who I would want. Okay, so there's no harm in listing guardians in your will. Okay. The final thing you're going to address in your will is your primary residence. And well, how does this fit into protection? So what we do with your primary residence is really going to flow from your vision for your child if something happens to the parents. In other words, is your child going to remain in the home they're in if they're living with you? Or is your vision that the house they're living in will be sold to fund their trust, and that child will go live with a guardian somewhere, or live in now comp housing, or live in a roommate situation? I don't know, and it's not a one-size-fits-all thing. This is your vision. What is best for your child? Okay, you need to make that decision, and then in your will, you will dictate what happens with that primary residence. Nothing is ever written in stone. It can always be changed. So, for example, for my family, it's very important that my son and my neurotypical daughter, who's 10, that they remain in the house. if something happens to my wife and I. Because my son knows the rooms. He knows the kitchen. He knows his room. He knows his sister's room. He knows the playroom, which is his safe area where he can go when he gets overwhelmed. I don't necessarily want him to lose mom and dad one day, and then the very next day, he lose his room and his yard and his neighbors. So it's become very, very important to stay in the house. So what we have done is we have said in our will, we are going to transfer our house when we pass away to my son's special needs trust. And hey, trustee, you are going to keep that house in that trust as long as it is in my son's best interest to stay in that house. And here are the rules on how you determine that. Where is his primary care physician? Where are his therapists? Is he becoming socially isolated, maybe living in this house? There are lots of factors in there. And we don't tie our trustees' hands, but I do tell the trustee and my executor, this is the initial plan. This is my plan today. We want to keep the house. We want my son and daughter to stay in it. Now, that may not be the right answer for your family. For your family, it may be, look, we want them to go live with their aunt in Macon. Well, that's great. But then you want to tell your executor, we want you to sell the house or keep it as a rental property. Come up with a plan. Okay. So that's how we used our will to protect our kids. Now think about how all of that's a protection. The flow of your assets is a protection. How much are we leaving to support our special needs child? That's a financial protection. Guardians. If my child needs a guardian, here are my choices. I'm protecting them personally and physically by choosing the right people. Primary residence. Where are they going to be living? I mean, that's incredibly important in determining their physical and mental well-being. So that's how your will fits into protections. So let's talk about trusts. How does the trust fit in? So, like I said in the beginning, most special needs kids need a trust of some sort. Whether it's a special needs trust or a regular trust is a bit of a question. But let's kind of back up. What is a trust? A trust is a legal entity that's created to hold assets. Those assets can be a house, can be a car, can be money, can be accounts, can be just about anything. Okay, so think about, I use a bucket analogy. So say your trust is an empty bucket. What a special needs trust does is anything you put into that bucket, the government ignores in determining your child's government benefits. Now, certain government benefits, we call them resource-based government benefits. That's SSI, Medicaid, Katie Beckett, and through Medicaid, things like the now comp waivers. Okay. Pretty obvious how these are protections for our kids, right? Because if you count on Katie Beckett, if you are going to count on SSI and Medicaid, if you're going to count on the now comp waiver, either now or in the future, then you need to contemplate a special needs trust. Okay. Because anything you put in there, the government says, we know it's there, but we're not going to count that against the $2,000 threshold. As you probably know, you cannot have more than $2,000 in your child's name and have them continue to qualify for things like Katie Beckett, now comp, SSI, and Medicaid. So where do you put that money to support them when we're gone? And that's the special needs trust. Okay. Another way to think of the trust. If we want to have strings attached to our money, our assets, and by strings, I mean, how's it going to be used? What's our wish for these things? What's our expectation on how the trustee is going to invest the money, spend the money? Anything like that. If you want to keep strings attached to your money or assets after you die, the only way to do it is through a trust. You cannot just say in your will, hey, I want you to use this money. I get this one a lot. I'm going to leave it to my special needs child's sibling. And in that way, I don't need a trust. And in my will, I'm going to say, sibling, please use this money to take care of your special needs sibling. Well, that's not legally binding on anyone. Once that money leaves your estate, is given to the neurotypical child, no strings attached. So do they have to use it to support their sibling? No, they don't. Okay. If you want to keep strings attached, it has to go in the trust. You can always put the neurotypical sibling as the trustee of the trust, but then they have to use those funds to support their special needs brother or sister. So if you want strings attached, that's how you do it. All right. So how is the trust used to protect benefits? Well, I just mentioned that. Anything you put in the trust, the government ignores in determining your child's benefits. All right. How's it used to protect money and assets? Well, once you put money, cash, assets, house, cars, anything in that trust, you can dictate to the trustee how those funds and assets are used. So, for example, let's say you want the money invested in a certain way. Look, I don't want you to invest, trustee, I don't want you to invest in real estate. Makes me uncomfortable, too much volatility. I want you to invest in large cap mutual funds. Well, you as the creator of the trust, if that's what you write in the trust, that is what the trustee has to do. They have to do that. If you don't want them to use trust funds to buy products from Apple, well, then they can't do it. But you see how you can build in whatever you want in terms of protections. You're also building guidance to your trustee in the trust. So, for example, trustee, I want you to use the money to engage a special needs advocate for my child until they graduate from high school or from any school. But again, you are more knowledgeable right now about the special needs world and community than your successor trustees will be. So when you say, look, this is what we really need. We need an IEP advocate. We need a care manager to manage all of their complex medical needs. Whatever it is, we can build those guidances in the trust. And if we build it in the trust, the trustee has to do it. Okay, so that's how we protect the money and the assets. Trusts also protect money and assets in case anyone ever gets sued. So back to that example of sometimes people will tell me they're leaving it to this typical sibling. Well, the problem with that is if the typical sibling gets sued, they're in a car accident, they're at fault, they get sued, or they get divorced. Well, that money, those assets that were given to the typical sibling, that is at risk in those situations. The person who sued them and they get a judgment, well, whatever you left the typical sibling, that's theirs. So the judgment can get to that. If the money or assets are in a trust, and even though the typical sibling controls the trust on behalf of their special needs sibling, if that typical sibling gets sued by that driver in the car accident, that driver cannot get to what's in the trust. It is protected. It's called asset protection. Okay. So the trust serves many, many different roles. But how do we use the trust to protect the person? Now, this is one that I feel really strongly about. Any of you who know my son or have spoken to me before, you know he has some pretty significant communication challenges. He's got some words. He's not nonverbal, but he cannot communicate at any kind of sophisticated level. So how do I protect him as a person in his trust? So what I do is, in the trust, I write in there, hey, trustee, when I'm gone, my wife is gone, even though you're controlling the money and the assets for my son, I want you to go visit my son in person every month. Once a month, I want you to go visit him. Now, I'll talk about trustees and guardians in a second, how they work together, but I'm always going to suggest your trustees and guardians be different people. And I'll explain that in a little bit. So right now, for this example, my trustee and my guardian are different people. Well, what am I doing by making sure my trustee goes to visit my son every month? Well, a couple things. One, it keeps him from being socially isolated, right? That trustee is going to visit him every month, take him out to the park, take him to lunch, take him to a movie, spend some time with him. The trust will pay for all of that, okay? So keeps him from being socially isolated, protecting his emotional well-being. And number two, I'm protecting his physical well-being, because we just can't tell the future. We don't know what's going to happen to our guardians in the future. We don't know where my son's necessarily going to be living in the future. So I want to make sure I've built in protections. So if the trustee goes to visit my son and he's gained weight, or he's lost weight, or God forbid he has a bruise on him, somebody is going to show up every month, and if anything happens, they will notice and they can do something about it. I don't want to leave that up to chance, that someone just happens to notice that he has a bruise on him. Okay. I want to make sure I have built-in protections, and I use the trust to do that. We just can't really tell. We do know, and everyone has some story or experience with this. We know that vulnerable people in our society, the elderly and special needs usually, neglect and abuse happens when no one's paying attention. If we build in a process through the trust where somebody is paying attention, the likelihood of neglect or abuse goes way, way, way down. So that's how we use the trust to protect them physically, emotionally. It's not just about money and assets. That's a big part of it. But we can also use it to protect them personally. Okay. How do we actually create this trust? So there are a number of ways to create the trust. I'm just going to touch on them briefly. It is not one size fits all. They all have pros and cons. One of the most common ways is we can create the special needs trust, or a regular trust, if that's what you choose for your child, in a will. And your will create a section of your will that says, here's the trust, or here's the special needs trust. And when I die, whatever I'm leaving to the trust, here's the percentage, or here's the name of the asset. Oh, and look in section 2 of my will, there are all the rules of the trust. And what happens is, when you pass away and your will's in front of the probate judge, that judge approves the creation of the trust, and then it springs to life and it's ready to be used. The downside to that option is we don't know how long it takes by the time your will gets in front of the judge and the time it gets approved. I can tell you today how long it takes, more or less, depending on your county. I can't tell you how long it's going to take 5, 10, 15 years from now. So that waiting period is a bit of a question mark. We can create what's called a living or standalone trust. That means we don't create the trust in your will, we create it outside of your will. Now, the benefit of that is, as soon as you sign it and put $1 in it, it's ready to go. No waiting period. As soon as that money's ready to flow from a bank account, or life insurance or from your estate, that trust is ready to receive it. The other benefit of the living or standalone trust is grandparents or aunts or uncles or anyone else who may be inclined to contribute to the trust and who may pass before you do can use that exact same living or standalone trust because it's ready to go. It can accept funds from any source. Okay, so nice benefit of that. The downside to it, of course, is it does cost a little more than just building it into your will. We can create a family trust for you and build a special needs trust into it. Benefit for that is it avoids probate altogether. Now, it's a much longer discussion on whether avoiding probate is worth the cost of building a family trust. We can get into that if we chat one-on-one at some point, but that's what the family trust is meant for. The living trust will avoid most probate, except for things like houses, cars, boats, things with a title. Anything with a title will still go through probate with a living standalone trust. There is something out there called a pooled trust, pooled special needs trust. What a pooled special needs trust is, it's a giant special needs trust that is created by a professional trust company, and it's managed by them. The benefits of the pooled trust is you've got all this professional money management, you've got CPAs, financial planners, attorneys who know about Social Security, tax attorneys. You've got all this professional management under one roof. The downside is with the pooled trust, you don't get to choose the trustee who manages it for your child. The company is the trustee. So pros and cons to each one of these choices. It's never one size fits all. So you do need to understand how these four options compare to each other and which one fits your family the best. All right. Just real quick, to make sure we draft a trust and a will properly, we have to understand what they can be used for and what they cannot be used for. So a special needs trust, the funds in a special needs trust can be used for any purpose to support the beneficiary, the special needs child, without affecting their benefits except food and shelter. If you use it for food and shelter, then the child's SSI cash benefit can start being reduced. Okay. Now, there is another option out there to pay for food and shelter, and that's an ABLE account. So consider an ABLE account before you pay for food and shelter out of a special needs trust. Because if you pay for food and shelter out of an ABLE account, the SSI cash benefit is not reduced at all. So there's, again, no one right answer to this, but you need to understand that it comes down to what the effective tax rates are at the time those payments are made. We don't know what those tax rates will be next year, 2, 5, 10, 15 years from now. So you want your trust drafted in such a way that it gives your trustee flexibility. What they want to think is, does it make more sense for me to cut a check from the special needs trust to pay for food and shelter for the special needs child, take the reduction in cash benefit, but not pay taxes on what I just spent because it's not in the trust when tax time rolls around? It's been spent. Or does it make more sense to cut the check from the special needs trust and put it into the ABLE account and pay for food and shelter directly from the ABLE account? That way I'm not paying taxes on it because I've paid it out of the trust. I'm not taking the reduction in SSI cash benefit because I'm not paying for food and shelter directly from the trust. But that is considered income from the trust to the ABLE account. It's income based on your child's tax rate, whatever that happens to be. So I don't know what those rates are. It's different for everybody and it'll be different in the future. But that is the process. And you want to build that process into your trust so your trustee has options to do what is best for your child. Okay. So again, what are we protecting here? Not only are we protecting benefits, but we're protecting our child's ability to be supported for food, for shelter, for anything else by determining where that money is going to come from to pay for those supports. And also making sure your trustee after you is educated on these processes. Now, different attorneys, different groups educate in different ways. You can go to groups like Focus, and they may have trainings on that kind of thing. What we do is, for our clients, we do put in educational material in their binders for their trustees. A simple down-to-earth explanation of what a special needs trust is, just kind of like I've explained it today, how it works with an ABLE account, as well as some other educational materials not even drafted by us, that are drafted by national organizations on how to be a good special needs trustee. But education of your trustee is really important. When it comes to benefits protection, it's the old adage, an ounce of prevention is worth a pound of cure. Okay. If we're careful up front, we're going to save a lot of time and expense in undoing mistakes if we make them. So it's just better to avoid the mistakes up front, and you avoid mistakes by educating your trustees. All right. Who's going to watch our kids when we can't do it anymore? Okay. And this is the hardest one, because we know how hard we all work to do everything we need to do for our kids. It doesn't really matter what their needs are, right? Their needs kind of expand to take up our bandwidth. So we do a lot. So it really comes down to, and it's not one size fits all, but there are different roles on who's going to look out for our kids when we're gone. Will it be an actual legal guardian? Someone appointed by a probate court to exercise your child's legal rights on their behalf by removing those rights from the child and giving it to the guardian. Certainly, if they're a minor under the age of 18, they're going to have a legal guardian if something happens to you. If they're 18 or older, it's really up to you and up to the court on whether guardianship's appropriate for that individual, whether they meet the legal standard. Regardless, even if it's not a guardian, most special needs kids do need some kind of assistance. Maybe that's done through power of attorney. Now, power of attorney is different than guardianship. It is the major alternative to guardianship. So with power of attorney, no rights are removed from your child. Your child keeps all their rights, but they are appointing the power of attorney, their agent, to exercise the child's rights on their behalf. So child's rights remain intact, but someone else can be appointed to speak on their behalf like an attorney would be. That's why it's called power of attorney. There's also supported decision-making I'll talk about in a minute. What's right for your child is completely different. It's going to be different for every family. Is it guardianship? Is it power of attorney? Is it supported decision-making? But the point is, you have to come up with a plan. Have a plan. Okay. I will tell you one of the things I get a lot. No one wants to take their own child's rights from them through the guardianship process. No one wants to do that. That's not to say it's not the right choice for some families. For my family, my son is not very high functioning, and so guardianship's going to be a no-brainer for us when he turns 18. For other people with higher functioning kids, it's a closer call. But what I get a lot from parents is they'll say, well, we haven't needed guardianship. I'll say, well, look, your child's significantly challenged, would clearly meet the legal standard. Is there a reason you haven't done it? Well, we haven't needed it. We've managed to get by. People have given us, people will still talk to us, the doctors, the schools, whoever. We haven't needed it. Well, two things about that I want you to remember. One is parents get benefit of the doubt from people that no one else will. So you go into a bank, you go into a doctor's office with your special needs child. Well, they're going to talk to mom and dad a lot of times because you're mom and dad, and they trust that you have your child's best interest at heart. They will not always give that benefit of the doubt to anyone else. Siblings, aunts, uncles, friends. No. So do you want to take that chance that just because you didn't have guardianship, that the people coming after you who will help your child won't need to have that legal authority to speak on your child's behalf? I mean, I get that all the time, where, we'll go when my wife's grandparents were in and out of the hospital before they passed, my wife would go in and, granddaughter, and they gave her some benefit of the doubt and would talk to her about their medical condition. Legally, they're not supposed to, but they did. I would go in and say, well, I am, the grandson-in-law. And they'd be like, yeah, no, we're not going to talk to you. Well, I would pull out the power of attorney or the guardianship papers or the HIPAA waiver, and I'd show it to them. Now they could talk to me and I could do what needed to be done for my wife's grandparents. You have to have the plan in place, the authority in place, not based on you, the parent today, because you will get the benefit of the doubt. It's for the people coming after you. Okay, you need to make those decisions. All right. Just legal standard for guardianship. In Georgia, the court, legal standard for adult guardianship, the court may appoint a guardian for an adult if the court finds the adult lacks sufficient capacity to make or communicate significant responsible decisions concerning his or her health or safety. I mean, that's the legal language from the statute. To me, that's not real useful for decision making for families. A couple of things I want you to think about when making the decision between power of attorney and guardianship. Under power of attorney, that's only going to be effective if your child understands what they're signing. They need to understand what power of attorney is at the 1,000-foot level. Keeping my rights, mom and dad will speak on my behalf with those rights. I can fire mom and dad. I can revoke this power of attorney whenever I want. They can, if they can understand that, they could most likely sign a power of attorney and have it be legally valid. If your child cannot understand that, even if they can physically sign it, it will not be valid. The other thing to understand is power of attorney, and again, no right, I am not advocating for one over the other, but power of attorney does not necessarily provide protections for your child because your child keeps all their rights. All of us should have power of attorney contemplated in our estate plans. My wife has power of attorney over me. I have it over her. Does not say a thing about capacity necessarily. Okay, so it doesn't mean anything. So if your child has capacity, signed power of attorney, gave you authority, they can still go out and sign things on their own and have it be legally valid. So not necessarily protections there. The other practical thing I like to have people think about in making this decision is an individual's interaction with law enforcement. And I know I'm running out of time here, so I'm not going to go into too many examples. But through my role as a judge in Gwinnett, I do work with law enforcement quite a bit. I work with the prosecutors and solicitors' offices. So I do ask them these questions from time to time. And ultimately, I've asked them in certain situations, if you have a special needs individual who is being accused of a crime, their case is on your desk, would it make any difference if you exercise your prosecutorial discretion on whether to prosecute something if there's power of attorney or guardianship in place? Every single prosecutor I've asked had said guardianship would make a difference. Some of them said power of attorney may make a difference depending on the facts and circumstances. The reason they gave me is power of attorney, again, is not really saying anything about capacity necessarily. Guardianship does. Under guardianship, a court of competent jurisdiction, which is your county probate court, has adjudicated the fact that your child lacks capacity to make or communicate significant responsible decisions concerning his or her health or safety. Well, that probably also includes the ability to make responsible decisions on their conduct. Do they even know what they're doing is potentially criminal conduct? Do they have the capacity to form that intent? Well, most prosecutors I've spoken to just said, look, we're not getting into that. We would find another way to dispose of the case. So again, no right or wrong answer here, but this is the information that I have gotten from the law enforcement community as well as district attorney and solicitors' offices. I will take questions at the end. When choosing a guardian, just a couple things, really think it through to choose good guardians. Where do they live? They live in your neighborhood. Do they live close by? Do they live in another state? They live in another state. Will your child's benefits change? Potentially. Would their therapist, primary care physician, dentist, will all that change? Yeah, it absolutely will change just by virtue of distance. Do your successor guardians, do they have the time to do what needs to be done? Do they have the patience? How do they handle stress? What's their health condition? I was talking to Jade before we started. I'm at the point in my life where I'm taking care of my elderly parents. When someone would have asked me 5 years ago, do I have time to be a successor guardian for someone? Sure, I did. Someone asked me right now, I don't. So is that one of those things where the person you're choosing may have to care for their own elderly parents on their own, right? Or do they have siblings, a network that can help with that? Do their kids have needs, special needs, or just general needs? You have to ask all the micro questions. But when you do talk to your guardians, talk to them about your life, be honest about what your average day looks like. It's not going to do them any good if you just spring it on them when they step into your shoes and they're like, this is not what I signed up for. Make sure you educate them on what your average day looks like and make sure they're up for that task, because being a special needs parent is not easy. Okay, so make sure that they know what they're signing up for. Educate your parents. Excuse me. Educate your guardians on how to care for your kids. Okay, because being a special needs parent is not intuitive. It's learned, and it's learned the hard way, through experience, through trial and error, through the fire. Okay, so 2 components to this. One is the basic information, day-to-day information. Who's their primary care physician? What are their allergies? What are their meds? Where are the meds kept? What's their next day look like? Is someone picking them up to go to the doctor? Is someone picking them up to go to a day program? Are you dropping them off? Do you have to pick them up? When do you pick them up? What does the next day look like after mom and dad are gone? So your guardian can step into your shoe. And when I say guardian, I mean guardian or power of attorney. They can step into your shoes and be successful. The second component in educating is what I call the tips and tricks that you have come up with that works for your family that gets you through the day. Is there a bedtime process, a bath time process, brushing the teeth process? Is there a sensory overload process? Are they afraid of animals? Do they not react well to animals? You've got to tell them. They're not going to, unless they live with you, they're not going to have all this information. And so, I always like to give an example from my own life about this. And in context, you have to put this information in context. One day, my wife and I just don't come home. That's when this information is going to be used. And the guardian's going to walk in the door. My kids know and love the guardian. That's not a problem. But my son is going to walk up to the guardian when it starts getting dark, because he knows mom and dad are the only ones who feed him and do his bedtime process and brush his teeth. And he's going to start getting some anxiety that things are different. And he's going to say to the guardian, Donna, I want Donna. And if I've spoken to any of you before, you see my presentations, you may have heard this example. But if I've not told the guardian what Donna means, practically what's going to happen is that night he's not going to eat, because eating's an issue for him. If he's not going to eat, he's not going to sleep, because reflux is an issue for him. If he's not going to sleep, the next day is going to be terrible. And we've taken what is basically going to be the worst day of his life, because mom and dad are instantly gone, and we've now made it more difficult. And we just cannot do that. And so him asking for Donna is him asking for, that's how he asked my wife and I to chase him around the house with his little stuffed shark. Because when we chase him around the house, we do the Jaws theme with it. We go Donna, Donna, Donna as we chase him around. And so that's what he's asking for. He wants to play with his stuffed shark to calm his system. And so I can't take that from him. I can't take his voice from him. And think of how easily that is solved in a letter to the guardian, instructions to the guardian. If he says Donna, he wants his stuffed shark. He's really his stuffed killer whale. That's normally in his bedroom or the playroom. He just wants you to play with him with it, doing the Jaws theme. That is 1.5 lines, and I have solved a big problem. You have to pass on the information that you've taken a lifetime to accumulate, because your guardians, successor power of attorney, they do not have a lifetime to learn what you already know. You've got to give it to them on day one. Okay. Alternatives to guardianship. I already mentioned power of attorney. Supported decision making that's a whole different topic. Supported decision making is not statutory in Georgia. It's basically a process. I do want to move on to some other issues, but basically supported decision making, in my opinion, is a process of educating the child, special needs individual, how to exercise their rights on their behalf, how to make good decisions. To me, you can use supported decision making within power of attorney. You can use it within guardianship. Just with guardianships in place doesn't mean you cannot continue to teach your child on how to make good decisions. It just means that the guardian has the ultimate decision making authority. So supported decision making is great, but it is not necessarily what I see as an alternative to guardianship, as much as a tool within guardianship and a tool within power of attorney. Guardians versus trustees, huge on building in protections. We suggest that they be different people, like I had said earlier, because guardians and trustees act as a check and balance on each other. The guardian is over the child or the individual. The trustee is over the assets. Now, of course, you trust these people. when you name them in your plan. But we have to accept that we cannot tell the future. And we do not know who the guardian or trustee will be 5, 10, 15 years from now. We've all had the experience with people we thought we knew, and it turns out we didn't. Okay. And so we don't know what's going to happen to these people, whether it's dementia, mental illness, substance abuse, divorce, financial pressure. People change over time, and we cannot risk our kids' well-being by not building in protections. So protection number one is splitting the roles, because the guardian can keep an eye on the trustee. The trustee can keep an eye on the guardian. How does the trustee do that? Like I said earlier, by building into the trust those visitations with the child. The guardian can keep an eye on the trustee because the guardian legally, or the power of attorney, can legally exercise the child's rights on their behalf. Well, included in those rights will be the right to potentially sue the trust or the trustee. If they've gone off the rails and they're stealing the money, the guardian can intervene. Now, in most cases, the guardian and the trustee work as a team, and they actually help each other, because being a special needs guardian is hard. Being a special needs trustee is hard. You don't necessarily want to put that all on one person. How do we build, what's our other options to build in protections? Well, let's say you want your guardian trustee to be the same person, which is fine. You absolutely can do that. You can build around it. So how do we build protections around it? You can name co-guardians or co-trustees, 2 people serving at the same time in those roles. It all comes down to an extra set of eyes. So if you have co-trustees, they have to agree on how the money's going to be used. And if you have one of those co-trustees is also the guardian, you make sure it's the other trustee who goes to physically visit your child. Let's say you don't want to do that, too much red tape. Well, you can build into your trust a role called a trust protector. Now, the trust protector role can take any form you want it to take. For my son's trust, we have the protector going in and occasionally doing an informal audit of the trust, and also going to visit, well, not my son, but because we don't have one, but going to go visit the beneficiary. But again, by building that role in, it's all about putting an extra set of eyes, both on the assets and the trust, as well as the child themselves. How you get those extra set of eyes can be splitting the role. It can be co-guardians or co-trustees, or it can be a trust protector, or any combination of those things. It all depends what fits your family. It's never one size fits all. Couple final words of advice. When making these decisions, what I suggest you do is look through a 5-year window. Assume something happens to both parents, or if you're single parent, to the single parent, within 5 years of your decision-making time. Because then you can kind of wrap your arms around that 5-year window. If you start looking 10, 15, 20 years down the road up front, when you're making these initial decisions, sometimes the decision-making becomes unmanageable and people end up not making decisions, which is not acceptable. You have to make these decisions, because if you don't, a court is going to make it for you. Do not get hung up on picking the perfect guardian or trustee. That's where people get stuck, because it's hard to find those people. It's hard to find people willing to do it, and it's hard to find people who have the skills to do it. But again, if you don't name somebody, a judge will. Okay, so you make the best decision you can of the people you have to choose from today. You do not have to wait and have all the answers before starting the process of getting these documents in place. A good special needs estate planning attorney will help you think it through. They don't just give you the questionnaire and say, fill it out. They give you the questionnaire, say, fill it out, and then we're going to talk about it. And we're going to help you if you get stuck. At some point, attorneys, you've heard attorneys called counselors. We were called counselors at one point because we used to actually give advice, not just implement what you tell us. Okay. Remember, anything you put in place today, as long as you're alive, or sometime if you're married, if you or your spouse is alive, you can make changes. It's not written in stone. Changes can be made easily, and it's not expensive to make them. But you cannot recover from not making an initial decision. Because obviously, if you're gone, you've not made a decision, that's going to be a real problem. Okay. All right. Just real quick, if you do want to speak to me one-on-one, you can schedule Zoom consultations with me online through my website. This is a picture of the website. There's a schedule now button right in the middle. Let's click that. Go down to estate plan consult. Click that. It has all my days and times of availability. Pick whatever works for you. The consults last between an hour and a half. We do charge for the consult. It's $200 for the consult. But if you do engage us to do an estate plan for you within 30 days of the consultation, we do apply the $200 to the cost of the plan. So for most people we do consults with, the consult ends up being free, essentially. So that's about it. Let me know what questions. I'm glad to address questions.
DJ, thank you so much. We definitely have some questions in the chat box. Some of the questions earlier are, is this being recorded? And yes, it's being recorded. It will be on the Focus website under parent support for workshop recordings within the week. So we do have that. And then one of your first questions is, what about if siblings of special needs adult or child pass away without a will?
If the siblings of special needs child pass away without a will, so if anyone passes away without a will in Georgia, it's going to pass according to a statute. So if that sibling has a spouse and kids, that's where it's going to go. It's not going to go to a sibling.
Thank you, DJ. Earlier, someone said you mentioned that you have a list of financial planners. Can they just get with you for a consult and get that?
If you want the list of financial planners, you don't have to do a consult with me to get those. You can just email me. My email's down here at the bottom. I'm pointing at this. I'm not even sharing it. Hold on. My email's at the bottom of this slide. It's dj@jlaw.com. If all you want is the list of financial planners, just shoot me an email, ask for that list. I'm glad to send that to you.
Thank you, DJ. Another question, a 529 can be changed over to an ABLE account, correct?
Yes, that's correct. Now, there can be restrictions on how much you can roll over at any one time, but the tax designation for the ABLE is a 529A. So it's really like a subset 529. So yes, it can be rolled over without affecting benefits.
Thank you. The second question to that is, if we die while having a 529 that needs to be converted to an ABLE account, how would that be directed? Would that be in the will, or should that be added to the will?
So the will is just about transferring of assets from one entity to another in terms of ownership. So if you want to have a 529 converted to an ABLE only after you pass away, then that's something you're going to want to make sure you address with a trustee.
Thank you, DJ. Someone else asked, is an ABLE account and a stable account the same thing? Yes, it is. Georgia uses the stable as an ABLE account. And then someone provided the link to the question of where can I set up an ABLE account? So that link is in the chat box for you that someone added. And then your next question, DJ, is would you speak to a disabled adult child? And then another question in that comment is SSI, SSDI, keeping Medicaid in conjunction with Medicare.
All right, I'm not sure I understand the question.
I think it's two questions. Would you speak to a disabled adult child?
Oh, just disabled adult child benefits. So that is like a 2-hour conversation. And so I'm gonna have to put a pin in that one. That is a long conversation.
Thoughts on making a single sibling the guardian and trustee, if siblings eventually marry? Question mark.
So making a single sibling the guardian and trustee, one is it makes me a little uncomfortable if you have other choices. Because if there's a single sibling, one, again, no matter who you're naming as guardian and trustee, you trust them today, but we just don't know who that sibling's going to be. And a bigger part of that, and I use the example of, dementia, mental illness, substance abuse, depression. I mean, it could be anything, but a huge part of that is who we end up being is who we marry. Where we see most special needs, and I think this is for all trusts, but for special needs trusts, where we see trustees going wrong with it, misusing funds, more often than not, it's not necessarily because it's the trustee who's doing something with it. It is the spouse of the trustee that's kind of whispering in their ear. I know that sounds terrible, but think about how much of an impact your spouse has on who you are today and decisions you make today. So that the person you're mentioning is not necessarily real stable in their life necessarily if they're not settled down with somebody. So I would just be cautious naming a single sibling, both guardian and trustee.
Thank you, DJ. That was great info. What are the next steps after the will and trust documents are completed?
So it depends. So what we say the next steps absolutely have to be is you go to your investment accounts, you go to your policies, you go to your bank account, you go to your 401s, anything with a beneficiary designation. And you change beneficiary designations to make sure it will flow from those funding sources directly to wherever you want it to go. So say it's 50% to a special needs trust, maybe 50% to a typical trust for a typical child. If you change those beneficiary designations, that's where the money goes. None of that goes through probate. It goes directly from the funding source to those trusts. So if we are careful about changing beneficiary designations, what's left to go through probate? Houses, cars, boats, anything with a title, which is just not that big a deal. So that's the number one thing you do after your trust is and your wills are finished.
Thank you, DJ. What if your child does not qualify for an ABLE account?
Well, if your child doesn't qualify for an ABLE account, they may not even need a special needs trust. It's going to depend on their level of functioning and whether the special needs trust is even needed. If their level of functioning is so high that they may not qualify for things like SSI and Medicaid, you may just need a regular trust for that child without the SSI regulatory requirements built in, just to help that child protect them from themselves sometimes from predators. The one thing is, if your child is so high functioning as not to qualify for ABLE or SSI, Medicaid, that kind of thing, when they're the higher functioning the individual, the more often they realize what they don't have, because they're that high functioning. And so they see friends, siblings, people who maybe have relationships that the individual doesn't have. And that sometimes opens them up to predators, because they become a little desperate for those relationships. And unfortunately, there are people out there who will take advantage of that. So sometimes a regular trust can help protect assets and money from these predators, and also protect the child from potentially being taken advantage of and making bad decisions.
Thank you, DJ. I'm not sure how much more time you have, but I can ask this question. If I have a POA for my adult child, can I state in the special needs trust that a new POA be executed if this option has been successful for my child?
No. So the power of attorney for the adult child is separate. The trust is going to be management of the asset. So what you want to do, if you want a new power of attorney executed with successors, I would document that in a couple of places. One, document it in the actual power of attorney, right? Hey, here, I'm power of attorney for my child. Here's who I want the successors to be. And it's really your child's power of attorney, so your child will sign off on those successors as well. But I'd also put it in that guardian letter, right? Look, power of attorney's been successful, guardianship's not appropriate, thought it through, talked it through. Power of attorney's been successful. We want that to continue.
Thank you, DJ. We've had some questions about the qualifications for an ABLE account. I attached that link to your questions that go directly to the georgiastable.com website. And then your last question for today, DJ, can be, once you have the trust and will all set up, can you purchase a home under the trust for that special needs child?
I mean, absolutely, you can. Yes.
Perfect. Thank you. Well, DJ, you've answered so many of our questions. You've given our parents so much time from your time today. So thank you for that. Thank you for walking us through everything. And then tell us again how they can reach you by email and telephone in case they want to set up that consult.
Sure. So the consult, again, the easiest way is just to go to our website, which is just jlaw.com. And right in the middle, you see a schedule now button. Click estate plan, and that has all my days and times of availability. Talk to your spouse or whoever else you want to be involved in that consult. And you just set it up right there. The consult fee can be paid online. And like I said, if you do engage us to do a plan for you, we apply the $200 to the cost of the plan. And honestly, at the end of the consult, if we're not the right fit for you, at least you've left, with an hour and a half of my time, with a good understanding of what you need to have in place for your family. And, that's a pretty big discount off my regular hourly rate. So yeah, I mean, I enjoy talking to the families, answering questions. If you have, one-off basic questions, feel free to just email me, or if you need the financial planner information, just email me directly at dj@jlaw.com. Email's always the best way to get me. I am unfortunately not the best at returning phone calls. I'm working on it, but email is always the best way to get me.
DJ, thank you so much. And of course, we look forward to seeing you soon, and we will be seeing you at our conference in January as well.
All right, thanks. Thanks for your time.
Thank you all. Bye-bye.